some necessary pain or suffering which is going to result on account of the activities which are permitted by the Act. For example, it says 11.1a, you shall recollect, says overloading is. Now, it doesn't mean that when you load, then there is no pain or suffering. But since the activity of loading the transport load is permitted, the rules specify how much weight can be carried, how many people can be carried. So if you are compliant with the rules, which are regulatory rules, and are limiting yourself to that, the pain is there, the suffering is there, but that is necessary not because that activity is permissible. Likewise, overdriving or overrides. So driving and riding are both permitted. And they will not, as the Lord Justice Joseph said, but they don't enjoy this whether somebody is riding, they are made to. So that pain is the necessary pain because the activity is permitted. In short, what I am driving at is that the expression unnecessary pain or suffering has to be construed in relation to the activity permitted. What is necessary and what is unnecessary pain.
How does the Act proceed? Does it proceed on the basis that some human person is owner of the animal?
Yes.
And in course of ownership, that human person's activities are regulated.
Yes.
To an extent. Is that the legal philosophy behind the Act? Ownership of the animal by the human person or animals are taken as a independent entity?
No, as in relation to the human being. Yeah. The entire Act is prevention of cruelty by whom? By the human beings. The entry has been put in entry 17 very carefully. It's negatively put, prevention. So the legislature will decide, while legislating under entry 17, what is cruelty they can define, how much pain or suffering can be made permissible and what will be unnecessary. It's all within the domain. This argument that you are perpetuating, the entry is prevention. But while exercising power in that field, the legislature will have to decide what is the definition of cruelty.
Any person, if any person, the person can only be a human being.
Yes.
So if the section 11, if any person beats, so it can only be by a human being.
That's it.
As to whether that understanding a person will continue in Article 21 and all that is a different issue.
Yeah, that's right. Now, in fact, if
there's a criminal act also.
Yes.
So that there must be, when you do this, there has to be a sort of mens rea, a certain mental framework that you are doing it deliberately. You are so, lacking in compassion.
That's right.
That you do this.
And even the definition of 2A animal is in relation to human being. Animal was not a human.
11A also suggests because kicks.
Kicks, somebody is kicking.
Overloads, all those torches everywhere.
That's right. The very entry 17 indicates that it is in relation to human being because somebody is being prevented from doing the cruelty. Most laws used to be anthropocentric, my lord. So therefore now with this ethics of compassion, which the human beings have realized on account of the environment, on account of it being a sentient being, or on account of the fact that we have to live with them.
There cannot be any doubt with respect to that because
Yes.
see also,
Yes.
any person willfully or unreasonably administrates.
Yes.
There is no question of an animal administrating another animal.
Yes.
It's only the human being.
Gratefulness. So therefore, it's in relation with human being, and there are activities which are permissible and which are regulated, and there are activities which are prohibited, which are regulated, and there are activities which are prohibited. There are activities which are totally kept out on account of some justifiable consideration about which the legislature has made value judgment. So unnecessary pain has to be construed in relation to the various clauses which by themselves or by the exemption clause grant liberty to the human being to do that act. Now, kindly see A11A for a second, Wallace. Beats, kicks, overrides, overdrives, overloads, tortures, or otherwise treats any animal so as to subject it to unnecessary pain. So now this last phrase runs through all the expressions. It's not that if the farmer while driving his bull to his farm for tilling, if he gives a kick by himself, that will draw the Criminalization Act provision. So as to cause unnecessary pain or suffering. This is very significant aspect of this act, not because this per se pain and suffering aspect. There are acts, permitted acts, which cause some pain or suffering per se. So that per se aspect, once exempted or once allowed, they stand overridden, or rather becomes permissible to that extent.
So that if you look at it from the perspective of essential human activities,
yes,
and non-essential human activities. For example, if you need the animal, do you domesticate the animal with that purpose only? So man has always needed animals, and the rest of the environment are necessary.
Yes.
So when it comes to sporting events, entertainment,
I'll come to sporting.
the area.
I'm conscious of Lordship's queries, my lords. The question is, my lords, if I may answer, my lord, in brief here itself. The legislature is entitled to exempt activities on some justifiable reason. Now, that justifiable reason could be based on religion, could be based on safety considerations, could be based on experimentation for curing diseases, etc. So there are a variety of factors which can, for example, killing for food. Now the food culture comes in. One can't imagine, if we ban fish, then where goes the machi jhol? So every state in India, has got subcultures. It's a multicultural country. So somewhere, you need biryani, somewhere machi jhol, somewhere, that mean, in the banana which is cooked in Kerala.
That's right.
So idea is that food, when it says, that clause says you can kill for food any animal. That is culture. It's not unavoidable thing. It's not something without which we cannot exist. If we pitch it at that level, everybody can survive. After all, the vegetarians and the vegans, they are surviving. So it's not that if we don't eat fish or we don't eat the muttons, etc., then we will die. It's not that. It's only the culture, the food habit, the choice. So large number of people are eating this. Now, how do you prevent straight away say that, sorry, ban? Now, the Muslims might say that our religion says that you will have halal. So 28 comes in. Extreme suffering. Not only killing, but killing in a manner. Because this 11.3, when it talks of killing, please have a look at this, very interesting, Lords. 11. 11(1)(L). Oh, I'm sorry. Which is the food one? Yes, 11(3)(E). 11(3)(E). Commission or omission of any act in the course of the destruction or the preparation for destruction of animal as food for mankind, unless such destruction or preparation was accompanied by infliction of unnecessary pain. So even when you are killing, don't do it in a manner. So stun the buffalo, then kill. Don't kill it in front of another buffalo. These are some minor changes. I don't know whether it really makes a difference to the buffalo mullets. Whether it's killed in front of another or not. But as they say, sentient being understands the pain of the other fellow buffaloes, if I may use this expression. So it says, unless such destruction has. Now look at this, even with regard to killing, the expression unnecessary pain or suffering is occurring. So since killing is permitted, all right, kill. That much pain and suffering we will tolerate. But while doing so, please ensure that either anesthesia is given or they are stunned or some. But had this been only E, then halal would not have been possible. So comes 28. Now here is the religious basis for this extreme pain justification. Nothing contained in this act, the whole act is overridden for extreme pain.
Yes.
Shall render it an offense to kill any animal in a manner required by the religion of any community. So then religion is a value which the legislature keeps in view in order to even permit extreme pain.
So, argument can be that non A to E. A to E deals with aspects either relating to the safety of the human being, like for example, destruction of stray dogs, for example, then extermination, then research for the real benefit of the human being, and E, which is food, which is considered to be
Now,
virtually essential.
So it's not all safety food is essential, but because of the food culture.
For example, you go to the hill area.
Yes.
As I discovered when I went to Nainital.
Yes.
I found that contrary to the practice in Kerala, where the Brahmins don't eat meat. I was in for something like a rude shock when I found many of my colleagues.
Yes, in the hill areas.
Helping, so they eat it. So the culture is, because the weather, you go to the Arctic, for example. Can you survive on vegetarian food? Maybe you can. There are people who.
Those who are vegetarian, they remain vegetarian when they go abroad.
But the conditions are so, the protein you need.
So that's how culture is born. Over a course of year, people living in a particular environment,
Correct.
necessity of environment or habit. Because when we are born, if our family is eating, generally
without meat also, without meat, one can survive. I am a living example.
Yes. Yes.
Man or human beings started as non-meat eater.
Yes, they were hunters. So we are all hunters actually.
That's right.
Then food gathering, then agriculture. But so things have evolved. Many have continued. So now we have more variety, more choices. And therefore, the food habits, the food culture is. So this is entirely food culture. So culture is definitely a basis, on the basis of which an exemption can be granted.
Your taste buds actually dictate.
Yes.
You see, when you find cooked non-vegetarian food on the plate, on the table, it is your taste buds which sends a signal to your brain.
That's right.
You're used to a particular taste. That makes you comfortable. Euphoria in your brain.
So, from taste neutral when we are born, we move on to some acquiring of taste.
That's right.
And The point is, which I'm making, now, the point I'm making is that it is for the legislature to decide which value judgment to attach weight and respect. Once they decide that on account of religion, we will tolerate extreme pain, that's a value judgment. Nobody can. Lord, we all know even religion has evolved and should evolve. We can't keep on saying that age-old practices, Lord, all some of them, Lord, initially may have been good, but today, Lord, from our understanding, are evil. So religion also must evolve. But is it a stage where we have reached where we can say that 28 needs to be deleted? It's for the legislature to decide, Lord, but we have reached that stage or not. A whole complex life is to be considered for that purpose. There is so much meat industry is there, employment is there, and so it's a huge complex.
Very correct. The question avoidable, whether it is avoidable alone cannot decide this.
Yes.
Because vegetarian survives, and
That's
therefore
right.
that cannot be a reason one can say in the strict sense. That means even without meat you can survive.
That's right.
But that cannot be.
So this essential, non-essential, avoidable, unavoidable, but this classification, my Lord, which was made in the previous judgment is completely erroneous. That doesn't, Lord, come out from this. And
Are you arguing that yes, there can be categorization, but the legislature must do it?
That's precisely my submission, my Lord. It is for the legislature to pick up a value, make a value judgment with regard to a particular activity, look at the people's, my Lord, habits, the people's culture, their lifestyle, the pattern of living. That is culture. And you take note of all those things and then make a value judgment. Is it the right time, my Lord, now to do it away, eliminate it, or to allow it? Allow it, then in what manner to allow it? All this is prevention of cruelty. Every cruelty cannot be abolished straight away.
But this value judgment theory, it is bound to change with the flux of time.
Yes.
With understanding.
Of course, Manoj.
So therefore, it can never be static.
No, it's certainly, I totally agree, Lord. Everything evolves. I'm myself saying even religion must evolve. But the point is, Lord, can in exercise of judicial review, the court, Lord, with all these imponderables, complex factors, is it possible at all, my Lords, to put it on a balance?
So, in a way, you are saying when Nagaraja was pronounced, the value judgments that prevailed at that point of time may have been all right, but with better understanding. But what is the change? You must tell us.
No, I'm not saying that when Nagaraj was delivered, it was all right. I'm saying Nagaraj was wrong in drawing this distinction of.
You are saying it's wrong.
Yes, avoidable, unavoidable, essential, unessential, and getting into that fact itself, Lord, in exercise of judicial review.
You are arguing in effect that animals do not have per se an independent enforceable right. Whatever, it's actually a regime of restriction which the legislature imposes on human beings.
Keeping in mind the constitutional mandates, on one side the human rights, on the other side the duty of compassion, they have to be, Lord, balanced, keeping the human rights superior, Lord. That is how it is. And otherwise, this Prevention of Corruption Act itself cannot, Lord, be sustained then. If you say kill and extreme kill because of religion, what is it? Because we human beings subscribe to a religion and we have chosen to subscribe, which mandates that you have to kill in this manner. So 28 comes in. Now Nagaraj says that this is ecocentric. I don't see how this PCA, the Prevention of Corruption Act, is
Cruelty to animals act.
Cruelty Act.
Why you are saying about
Nagaraj says that this is ecocentric, whereas the state amendment of 2009.
So you are referring to Prevention of Corruption, that is.
Yes, Prevention of Corruption Act made by the central government, Parliament. Nagaraj said that this is ecocentric, whereas state act.
Cruelty
to animals act.
You are talking about corruption. You said corruption.
That is why.
Prevention of Cruelty Act is ecocentric, whereas the state act Let me use Central Act and State Act.
So it's better to say PC Act.
Yes,
PCA.
PC Act.
To avoid the other.
That's right. So PC Act, my lord, is ecocentric, whereas State Act is anthropocentric. Now, how do we characterize my lord, this PC Act as ecocentric? My lord? The whole 11.3, 14, 17, which it says for military training, etc., 28, all of them are anthropocentric. This whole act is anthropocentric, but it tries to balance in its own way.
The balancing.
It tries to balance in its own way the duty of compassion. Whether we will not extract this duty of compassion from the animal being sentient or the environment, compassion or human dignity, the fact that we are living with animals, they are our resource. So from whichever way we derive, Lord, what comes out is not the right, but a duty of compassion. And unlike these foreign judgments, we don't need to go around, Lord, and pitch our sense of duty, Lord, on dignity and environment, etc. Because we have Article 51A, Lord, which requires balancing. So we don't need to go other countries, Lord, where they did not have. For example, Lord, in that monkey case, Ecuador, they drew it from the nature. Because we are all part of nature, and therefore, Lord, from there they drew this duty. They recognize the animal right, but they say it is not equal to human right. It is subservient to human right. So ultimately, Lord, you may call it right, but it becomes subservient to human right. So whichever way we look at it, there is an element of balancing which the parliament and the state legislature has to do. And when it does that balancing and permits some act, then the pain and suffering which is inevitable, incidental, or per se involved in that becomes exempted. The cruel aspects remain. Now, coming to the second aspect, Lord, I hope not I have made myself clear on this unnecessary pain or suffering. Lord.
That's right.
In fact, if your Lordship will look at 11.1D, conveys or carries whether in or upon any vehicle or not in any such manner or position as to subject it to unnecessary pain or suffering. So when you carry it on a vehicle, you have to chain it. Some pain or suffering is inevitable.
What about 11B? Last time also we asked you. 11B. Please read 11B.
Employs in any work or labor for any purpose any animal which by reason of its age or disease, infirmity, wound, sore or other case is unfit to be employed.
What you'd like to highlight is employees just jump over to for any purpose and or other cause unfit to be so employed. Permit?
Yes.
Now here if you just use for any purpose.
Other cause will have to be read ejusdem generis, Lord.
So other cause is when the bull is naturally not, suited for, that's what this is Radhakrishnan discusses.
No, that in my humble submission, Lord, look at
other cause.
Lord, ejusdem generis has to draw, the bird will have to draw the color from the preceding birds. The birds of feather flock together, Lord.
Or other cause is very wide.
Other cause is wide, but every time when the words are otherwise, or for other causes, then Lord, one has to look at the previous words, namely disease, infirmity, wound, sore, something, Lord, which is the body itself is suffering because of ailment. Age, disease, infirmity, wound, sore. Look at the collection of words, Lord.
That depends on your, dynamics of your interpretation. You want to place a dynamic interpretation suited to welfare of the animals. You could say, like, when it's afflicted with gross fear. That is the whole, see, ultimately.
Now, let me take the subsequent expression.
Yeah.
Because of other cause is unfit to be so employed.
Unfit.
So before employment, he is already suffering from, not after employment. It says, for other cause is unfit to be so employed.
That's right.
So pre-employment,
That's right.
if he is suffering, so I can't pick up a diseased animal and
Because it means from your previous experience, you have watched how the animal reacts when there are cheering crowd, whichever way you put it, and of all that it did in Nagaraja, which you have removed now. But still the substratum of fear remains, that you let loose the animal.
But
You
that's
know
where-
the animal is surrounded by
that's-
about 14 men.
I understand, Lord. But that's where I'm submitting, Lord, that once the legislature exempts,
The value difference.
then the pain and fear element, Lord, which is inevitable and inherent, that is what the exemption is taking care of. The per se pain, the inevitable pain and fear, or the incidental pain or suffering on account of the activity, that is what is taken care alone. I'm emphasizing the word alone, Lord, so that the cruelty, extra cruelty aspects, Lord, are eliminated.
That is the reason you have a veterinary doctor
Yes,
and you take the fitness.
yes.
And only after the fitness,
Is cleared, then
then only he is permitted
yes,
to part.
that's it. I'm grateful.
That is the subsection 3.
Yes.
But then what will the veterinary doctor certify about what the bull is going to experience?
No,
So then it will fall under
it's
necessary.
unfit because of
Yes.
this, otherwise that is sufficient.
That's my humble
The
submission.
animal is fit.
That's how this unnecessary word, we have to attach some.
See, there is a thing called post-traumatic stress syndrome. It is one of the well-recognized psychiatric disorders. Supposing you had gone through a harrowing experience in life, human beings,
Yes.
there is even the hint of a resemblance of a repeat happening, going to happen. It can trigger that stress syndrome. In London, in fact, a person committed murder and then he set up this defense. He said that immediately I went back to that experience. I thought it's going to come, and therefore I did it. The stress.
So, Lord, my submission still remains the same, Lord, with respect, Lord, that stress, that pain, that fear, which is inevitable, incidental, Lord, on account of the activity which has been permitted by the legislature in its wisdom and decriminalized it. That's also very vital, Lord. 28A, which my learned friends were emphasizing all the time, Lord. 28A, it is no more Jallikattu, conducting Jallikattu is no more an offense. Now it is the legislature's domain, Lord, to criminalize or not to criminalize. 28A is a standalone provision. Nothing can compel the legislature, Lord, to criminalize it, to make an offense. Even if other provisions are ignored, Lord, there is no offense now. That is standalone. Now, may I come, Lord, with this to 11.3? How do we look at this non-obstante? And this is in the context of my Lord's query about 11.1 being overridden, my Lords. And that if my submission, my Lord, founds it comments to your Lordship, Lord, then that will take care of 254.2 also.
Do you have a
Sorry.
standalone copy of the Tamil Nadu amendment?
Yes, it is annexed, Lord. It is.
No, annexed.
He just wants a slim copy.
Yes.
Each time we don't have to go through.
Okay, all right.
That is cruelty to the judge.
That is why this expression is used as standalone.
Necessary pain.
Standalone.
That's unnecessary pain. Can be avoided. Each time we go through it, where is he? Everybody.
Alex is in that.
Everybody.
Get a print out of it.
Avoidable. Avoidable.
Other clauses using this expression, I'm not dealing with it. In my submission, I have dealt with all those clauses. Now, please come to 11.3 minutes straight away. Please see this. Nothing in this section shall apply to these expressions. I'm taking this, the first expression, dehorning of capital. Dehorning of cattle. Does it mean, my lords, that while I'm taking my cattle for dehorning, I can keep on brutalizing by kicking?
Obviously not.
Not first.
In the Doberman breed, there's a detailing of the a particular breed also.
Now look at castration.
Just one. Yes.
Now look at castration, my lord. If I'm taking my cattle, my lord, for castration, can I go on, my lord, beating, kicking, overriding? No.
No.
Likewise, branding, my lords. Nose roping. Now, much was said about nose roping by petitioners also, and nose roping is permitted by Parliament itself. In the manner prescribed.
That's right.
Now, when I'm nose roping, I'm not entitled to keep on kicking. But the point I'm making is that the non-obstante clause is limited to the activity permitted, and it does not totally override 11.1.
Yeah.
So 11.1, the very fact that Jallikattu is included as F does not entitle anybody to beat, kick, override, torture. Once this interpretation is accepted, my lord, then things fall in place. The Act itself is not regulating. The Central Act provides by 11.1 what is not to be done. And notwithstanding is only permitting that which is expressly mentioned and nothing more.
Yeah.
Now, there is a judgment of your lordships where your lordships have explained how to read, my lord, a non-obstante clause. 2009 4 SCC 94.
Chakravarti.
4 SCC 94.
Central Bank.
Swami decision.
I'm drawing your lordship's attention to paragraph 98 onwards, that is at page 130. If I may just mention, my lord, what was the issue in this case was that the state of Kerala had in its Sales Tax Act made a provision that the recovery of debt will be the first charge. Now then came the Recovery of Debt Act and the Sarfazi Act, Lord, and the issue was raised by the bank that my debts are over the state's debt, and that was the controversy. And they relied upon the non-obstante provision to say that everything in the State Act goes. Now, 98 to 101, my lord, just they prescribe the normal principle well known to your lordship, about textual, contextual, purposive, and all that. Then kindly come to 103, page 132. A non-obstante clause is generally incorporated in a statute to give overriding effect to a particular section of the statute as a whole. Your lordships have this provision. Lord Justice Joseph has 103, page 132.
Page 1, okay, para 1.
103.
Yes, yes.
A non-obstante clause is generally incorporated in a statute to give overriding effect to a particular section of the statute as a whole. While interpreting non-obstante clause, the court is required to find out the extent to which the legislature intended to do so, and the context in which the non-obstante clause is used. This rule of interpretation has been applied in several decisions. When State Bank of West Bengal versus Union of India, the court must ascertain the intention of the legislature by directing its attention not merely to the clauses to be construed, but to the entire statute. It must compare the clause with the other parts of the law and the setting in which the clause to be interpreted occurs. In Madhav Rao, Chief Justice Hidayatullah observed that the non-obstante clause is no doubt a very potent clause intended to exclude every consideration arising from other provisions of the same statute or other statute. But for that reason alone, we must determine the scope of that provision strictly.
Yes.
When the section containing the said clause does not refer to any particular provisions which it intends to override, but refers to the provisions of the statute generally, it is not permissible to hold that it excludes the whole act and stands all alone by itself.
Yeah.
A search has therefore to be made with a view to determining which provision answers the description and which does not. In R.S. Raghunath, a three-judge bench referred to earlier judgments in so and so, and then court's para 11 is extracted. The non-obstante clause is appended to a provision with a view to give the enacting part of the provision an overriding effect in case of a conflict. But the non-obstante clause need not necessarily and always be coextensive with the operative part so as to have the effect of cutting down the clear terms of an enactment. And if the words of an enactment are clear and are capable of a clear interpretation on a plain and grammatical construction of the words, the non-obstante clause cannot cut down the construction and restrict the scope of its operation. In such cases, the non-obstante clause has to be read as clarifying the whole position and must be understood to have been incorporated in the enactment by the legislature by way of abundant caution and not by way of limiting the ambit and scope of the special rules. In Varadarajulu versus State of Tamil Nadu, then the extracted portion, it is well settled that while dealing with a non-obstante clause under the legislature wants to give overriding effect to a section, the court must try to find out the extent to which the legislature had intended to give one provision overriding effect over another provision. Such intention of the legislature in this behalf is to be gathered from the enacting part of the section. In Ashwini Kumar Ghosh, the enacting part of a statute must, where it is clear, be taken to control the non-obstante clause where both cannot be read harmoniously. The DRT Act and the securitizations were enacted by Parliament in the backdrop of recommendations made by so and so. Then kindly have the next page.
Yes.
However, 111. However, what is most significant to be noted is that there is no provision in either of these enactments by which the first charge has been created in favor of banks, financial institutions, or secured creditors who are the property of the borrower. Under Section 13(1), the Securitization Act, limited primacy has been given to the right of the secured creditor to enforce security interests vis-a-vis Section 69 or 69A of the Transfer of Property Act. In terms of that subsection, a secured creditor can enforce security interest without intervention of court or tribunal, and if the borrower has created so on. So the point is not that we have to first read the main clauses and see what is it that is permitted. Only to that extent 11(1) is overridden. The whole of 11(1)A will not go.
Yes.
So what is essential, necessary for conducting Jallikattu, that alone will remain. The clause of Tamil Nadu now says Jallikattu, which is conducted in accordance with the culture and taking care of the well-being. Our rules elaborate on 11(1)A. We provide for what will be the contours of the arena, what will be the runway, the bull run area, the collection point. Before the veterinary experts are there, they will look into it. So all that has been prescribed. So the rule is adding upon what is there in 11(1)A. This beating, kicking, overriding, overloading, torture, etc., which treats animal, that part is not overridden. So therefore, biting of tail and use of chili, drugs, etc., cannot be given because C is there, 11(1)C.
Yes.
So these three aspects with regard to the act I wish to point out, my lords.
Yeah.
And if I am right, my lord, then on this, then what follows from this is that when our act was sent to the president under 254(2), now the act itself is showing, my lord, that we want to insert exemptions, my lord, in these provisions. The bill is very clear. And the bill is seeking to insert that exemption in the PC Act. So the president is fully aware, my lord, that at what point there is a contradiction and what exemption is being sought and where it is being inserted in the PC Act. It is not at all necessary, my lord, at that stage that the rule should have been done. What is the rule doing? The rule is not either reiterating what 11(1)(a) is there, or, my lord, it is expanding on this prescription about the space, giving of water, ensuring water is given, 60 square feet for each animal. So all those things are additional. So whether that rule is added upon or subtracted upon, ultimately 11(1) was clearly there as a protection, preventing unnecessary pain or suffering.
See, the Prevention Act of 1960, it repealed the 1890 Act.
Yes.
Now, the 1890 Act is essentially, you will find, it's almost the same. But a committee went into certain inadequacies.
Like the board was formed, which was not there.
You have a report of that committee. Have you gone through the committee? What is it that led to the amendments?
In the SOR, my lords,
This is 1890 Act.
the statement of object is there in the beginning, my lords, that mentions to some extent.
That's right. No, it's essentially the same,
We'll get, yes.
except that a very treating animals cruelly is a title, section 11.
Yes.
The earlier section was penalty, but ultimately it is a penal provision.
Yes.
It did to create an offense. That Salmon, when he said that when somebody in interpreting the laws in England, which virtually are reflected in India, you create a duty, and if you violate the duty, it leads to an offense. That doesn't mean that a right is created.
Yes.
The distinction between, because it is for the purpose of defining an offense, that the section sets out what constitutes offense. Creating the offense by itself doesn't create a right in favor of the animal. And Salmon goes on to say that in the eastern countries, like we are, they have rights for idols, and that specific rights are created in favor of rights.
Yes, those rights were created as long custom.
Long.
Yes.
But in law, jurisprudentially, there can possibly be no obstacle in creating rights for animals, is what Salmon says.
So certainly, not by statute, certain rights have been given. That, namely, one right is that unnecessary pain or suffering should not be there.
No, but it's not a right. See, the point is, it's not a right. You have to understand.
That comes out as a duty.
It is a duty on the
Yes.
human being.
That's right.
Which
I
is to
stand-
violate
yes.
leads to him being punishable. That is different from a right.
But if an act dealing with the animals not wishes to create a right, statutory right, it can.
It can.
But these are not for the thing for the legislature to decide,
That's right.
whether we have reached a stage where we need to
Because
give that right.
What you're saying is that it repealed the 1890 Act. So apart from certain changes which were brought about, for example, the 1890 Act was applicable only in the municipal areas.
Yes.
Now
This applies wider area.
animal was defined differently, captured, etc., etc. Now it is expanded the meaning of the word animal.
Yes.
So there have been improvements, but the essential substratum remained the same.
Same.
The only change that is brought about is with the onset of the Constitution. Compassion, Article 21, whether it's attracted and things like that.
Even that compassion comes much late, not in the
That's
beginning.
right.
But so it's evolving. The best thing is that shows that legislatures are aware and they're trying to do their utmost and balance. It's a complex balancing exercise. Now, having said that, the next aspect, I have already pointed out section 28 about that criminalization aspect, because 28 is a standalone provision. Once it is decriminalized, it would not be permissible to strike it down to say not that criminalization will remain. There can be regulations without criminalization. So 28 is standalone, and nothing has been pointed out, not independently, to say that it is manifestly arbitrary. Now, Lord, coming to the aspect of competence, what Mr. Venugopal submitted about 17, that you are providing for perpetuation and not prevention.
Yes. Yeah.
Now, my lords, 17, when it says prevention of cruelty to animals, my submission is that while legislating under this head, in this field, both Parliament and state legislatures are entitled A, to define what is cruelty, B, to decide which cruelty is to be prohibited,
Yeah.
and C, which aspects of cruelty are those which are merely to be regulated, and which of them have to be left untouched, like section 28. So therefore, it can't be said that if the Parliament, I'm taking the original act, if the Parliament decides not to regulate a particular activity which is covered by 28, then it cannot be said that the Parliament is perpetuating cruelty. It is just that that cruelty is based on religion and Parliament doesn't want to regulate it. So this entry 17, when it talks of prevention, it is necessarily implicit that the legislature will have all this power, panoply of powers. This field is not a limited field that every time, for example, supposing Parliament had not made Prevention of Cruelty Act at all, so all these cruelties would have continued.
Can they come to section 428 and 429 of the Indian Penal Code?
Yes.
428 and 429 of the Indian Penal Code.
Twenty-eight.
428, 429.
Whoever commits, may I please it?
Yeah.
Whoever commits mischief by killing, poisoning, maiming, rendering useless any animals of the value of 10 rupees or upwards shall be punished with imprisonment. Either description for a term which may extend to 2 years or with fine or with both. Then 429 says, whoever commits mischief by killing, poisoning, maiming or rendering useless any elephant, camel, horse, mule, buffalo, bull, cow or ox, whatever be the value thereof, or any other animal of the value of 50 rupees or upward shall be punished. So these provisions remain.
You know, what you wanted to bring to your notice was, if you come to section 11 of the Cruelty Act,
Yes, Manoj.
it's an 1960 Act, it's after the Penal Code. If you come to 11L,
Yes.
now it speaks about
Mutilates any animal or kills any animal
by
Including
using
stray
the
dogs?
or any other
Injections.
unnecessarily cruel manner, what we are concerned with is he shall be punishable in the case of a first offence with fine not to exceed 10 rupees.
Yes.
So if he does it for the first time, if you have the choice of applying section 428 or 429, it under the ironically the act which is supposed to take care of animals, it visits him with 10 rupees.
10 rupees.
And there you can punish him for 5 years. So which will survive actually? Whether after the enactment of this 1960, both are by the central government, both by the central parliament.
No, both will survive, not because the first part of L talks of the use of method of strychnine injections.
Or any other manner.
Or in any other manner. So that's widens.
So any other cruel manner. So if you look at the irony of it, if you do it in a very cruel manner, you will be punished with a lighter sentence. Whereas if you kill in the manner provided in the section 429, it can go up to 5 years.
Yes.
I mean, we find it a little.
But that is based on mischief, who commits mischief and thereby causes.
So, I mean, it's somebody else's property. So basically,
Yes.
animals have always been regarded as chattels and properties.
Yes.
In England.
Yes.
Continue to be so.
That's right. That contradiction is there.
Yes.
Here. So the 428 and 429, it doesn't gel well with the scheme of the act. Because it can be anybody else's mischievous. If you do it with your own animal, perhaps it is not mischief.
And this was inserted in 82. L.
That's it. And they were even more, clear about it because animal was basically treated as having value.
Yes.
As a
right.
chattel, as a thing, as they
Yes.
call it in England, it's called a thing. Now the movement is to not call it a thing. It's an insult to call it a thing. It is a sentient being, as you rightly pointed out.
But we use these expressions, but ultimately the market
Ultimately, you
treats
call
them
it a
as
thing.
property.
Ultimately, you call it a thing. in your
Market
mind.
treats them as a thing and property. No, that's how they are
Just wanted to point.
bought and sold and
Livestock.
slaughtered and meat is sold. So all
Here it
through.
is 10 rupees. Then you will get away. So depending on you can be charged under this section or that section.
Does it also the kind of way the same kind of offences are being treated, difference of legislative value also? It is the same legislation which is
May I proceed, Mr.?
Where is the confusion? Both will sustain. No
Yes.
overlapping, nothing, yes. Any offense if committed under the IPC, in addition to what is the offense is punishable under the act, will you have to face the consequence. Where is
Oh,
the-
there can be a charge under both.
Yes, if you commit any kind of offense under the IPC, you have to be equally punished.
And all those questions will arise, Lord, if and when somebody questions, Lord, that which, because of Article 20, which one, Lord, will be, for our present purposes, Lord.
Yeah.
So I was on entry 17, Lord, of the Constitution.
Correct.
And my respectful submission was, Lord, that this entry does not take away the power of the Parliament or the legislature to prescribe for exemptions and regulations. And it is for the legislature to decide which cruelty is to be prevented, which is to be regulated, and which is allowed to remain as such, as in case of Section 28.
What do you say to the two judgments he relied on? He relied on two judgments.
That was not the case of tax, not where under the mines and mineral, not where they said that you can charge a particular tax or royalty.
That's right.
On the mining in the land, but it was all that judgment has been referred to 9 judges now, Lord. Finally, much of that judgment, Lord, based on synthetic chemicals itself. Synthetic chemicals stands much diluted, Lord. The first onslaught came in 91 itself, when sale tax part which was dealt was, Lord, declared to be per incurium. And then, Lord, in Bihar distilleries case, Justice Jeevan Reddy, Lord, declared that this, so far as it dealing with license of potable liquor, that is not covered by synthetics. So that judgment, Lord, itself is much eroded. The judgment my learned friend referred will all be considered by a 9 judges judgment now, because synthetics is referred.
That's right. That's right.
So therefore, Lord, there being a land or being a space, Lord, which is being taxed, because even if you dug up the land, Lord, what remains is still land, Lord. But we don't need to go into tax aspects and all that. That was a different entry. And I'm putting a question, supposing Parliament had not made the act at all, my lords, then whatever was going on would have gone on.
Then possibly 428, 429.
Yes, 428 would have applied. In fact, Jallikattu has been going on till 2014 until this Nagaraj judgment came. Before Nagaraj, no, it is the central government which came out with a notification saying that bull is not a performing animal. And that was the cause for the judgment.
Actually, 428, 429 proceeds on the basis of the offence of mischief under 425, which deals with whoever with intent to cause or doing that is likely to cause wrongful loss or damage to the public or to any person causes the destruction of any property. So this is a throwback to the bygone era where animals have been treated as property. This is a sort of reflection of that sentiment that you had.
Yes.
That they were property. You cause destruction of somebody's property section. So both offences can be pressed.
Can be pressed. So, Lord, that question will arise as and when, Lord, the charge is pressed, Lord, and both charges are there. Somebody may.
We are just saying that sentiment was this property in 1890.
Now, what is the tax treatment for accounting purpose? Somebody is owning a prize-winning horse. Is it reflected in the balance sheet as an asset or property?
House. Take a horse.
Any chartered accountant
What is accepted as
among us?
So therefore, Lord, entry. The law is, Lord, that entries have to be construed liberally, widely. They are field of legislation.
Yes.
So it is for Parliament and legislature to decide, Lord, which one to control, prohibit, regulate. So the different, Lord, methodologies are available to deal with this issue.
then will it not make it open, expose it to the charge that it is manifestly arbitrary? You make a law under entry 17. It is not an essential activity for the human beings. It is entertainment for them at any rate. Culture, we call it. And you subject the animal to cruelty in an entry which relates.
If culture is a fundamental right under Article 29(1), why cannot it be made a basis, my lord, of justifying an exemption based on 29(1) if that activity has been going on for a very long time? In a particular season, without, my lord, variation. Since ages. And we have set out in our counter affidavit, and there is a research also done by Jawaharlal Nehru University, my lord, which all indicates that this is very old, my lord. And there are rock paintings available, my lord, where this depicting, my lord, this is going on. And even Justice Radhakrishnan doesn't say that it's not culture. He says in the form in which it is being done, it's not. So he's merely pained at the cruelties which were being practiced. And that led to this. Certainly, we have to make all out efforts.
What is the material for culture which you have?
Yes, I'm coming straight to that. But right now, 17 lot is very wide. And incidentally, I may also point out entry 33. My learned friend pointed out entry 15. Kindly see entry 33, list 2. Even if we take it as a sport or entertainment.
Yes.
Possibly treated as assets.
There are sports which are not pure and simple sports like the cricket which we have. Around the year it goes on in different forms. And there are sports, my lord, which are meant for rural people, my lord, who can't have polo ride, my lord, on the horse and who cannot. So they want a cart race.
Entertainment.
Yes, and sports and entertainment. But it has an aspect of prevention of cruelty, therefore, Lot 17 also gets attracted. Now, a word about 254(2) further, my lords. As I said that the Principal Act 11(1) survives, so that was there, the assent was properly given, no necessity at all for the rules being submitted. But more than that, my lord, in this judgment which my learned friends relied, that is Kaisar-e Hind. Lord, if your lordship recollect, in Kaisar-e Hind, what happened was that there was a Rent Control Act made by Maharashtra. Now it was conflicting with
Citation.
2002 volume 8 SEC 182, which is at serial number 20 of petitioners compilation. So the issue here was that the State Act was conflicting with more than one central enactments. And the assent of the president had been sought only with respect to one of them. So this court said that we will not go, the validity of the assent cannot be tested. That's beyond judicial review. But we can see the coverage.
Malad, we are a little confused because Mr. Dwivedi keeps referring to a counter affidavit. We are in the first matter. My learned friends are in some of the other matters. We have never received a counter affidavit of any kind.
So many articles which they are giving to us, Lord, across the board here.
No, that's
now we are on a constitutional matter, not on a large matter. Now
the difficulty, my lords, is this.
My learned friend should have taken a counter affidavit. He has been raising this objection. He could have asked and he would have given.
No. Is there a counter affidavit? Is the question. I just asked. I was told there's a written submission. And we have never been served with a counter. My learned friend can't say there is material to establish culture without a counter affidavit. And there is a finding of fact in Nagaraj that it is not a case of culture. No material is there. So I'm not clear on how my learned friend is arguing this entire
I'm
point.
sorry you never asked me, I would have given you.
No.
In writ petition number 24, it is there. A common counter was filed.
Who is it? Petition 24?
24.
We don't have such a counter.
Having is something which you
No,
would
but you
have asked me, I would have given you over a dinner.
No, we we asked on previous hearings, mentioned
Not to be
specifically,
fair.
there's no counter.
Not-
And we were told there is some vague document, but nobody ever gave us a
Mr.
document.
Venugopal, why you have this controversy? Take the counter now and go through it.
Please hand over a copy of the counter. We've not had a chance to controvert it, Malutz, by filing a rejoinder also.
Mr. Grover filed an application for 254, Lord, we are not objecting, we are producing file and all, but all right, have it now.
You give me a. Hello.
Kindly have paragraph 25.
Yeah.
So kindly have paragraph 20 minutes. I'm sorry, paragraph 20.
20 and
It is true that President's assent as notified. In the Act, nowhere mentions that assent was obtained qua repugnancy between the state legislation and specified certain laws or laws of parliament. But from this, it also cannot be inferred that as the president has given assent, all earlier laws or laws on the subject would not prevail in the state. As discussed above, before grant of the assent, consideration of the reasons for having such law is necessary, and the consideration would mean consideration of the proposal made by the state for the law enacted despite it being repugnant to the earlier law made by parliament on the same subject. If the proposal made by the state is limited qua the repugnancy of state law and law or laws specified in the said proposal, then it cannot be said that the assent was granted qua the repugnancy between the state law and the other laws for which no assent was sought or given. So that was the position in this case. Only this much has been permitted. Assent otherwise cannot be challenged. No judicial review is permissible on the assent, whether it was manifestly arbitrary and this and that. Only the coverage is to be seen. And in this case, there is only one law. It's nobody's case that there are three other laws with which our state amendment is contradictory. We have not walked considerable length as regards pleading is concerned, but in para 30 minutes of my written submission at page 12, I have given a judgment 2004-6 SCC, which says that there must be a clear pleading challenge. But of course, they have moved an application now, if your lordships are willing to entertain. But I have argued on the basis of first principles.
you didn't complete the citation 2000.
2004-6 SCC, page 36, paragraph 38 and 39. And that is contained in volume 3 of the 3 volumes which were given by Mr. Sibal yesterday. I have given the pages, etc. at page 13 of my. Then I don't need to give it. I'm not reading it just because I need to. Should I read it?
Be faster.
Yes, I'm therefore moving onwards. I don't want to read this. I was myself looking at the watch. Now coming to culture, please have my written note. I have tried to extract as much as possible so that rest material we have enclosed.
Because Venugopal said there's a finding in Nagraj that this is not part of culture. In the form it is practiced.
That's right. So in the form, it is practiced, it is not. That's why our exemption says that Jallikattu, which is permitted by the culture, not that which is not permitted. Para 53, 55, 4, which your lordships are referring.
Yeah.
Now, my first submission is that fact that it is part of the culture has been legislatively determined by the state of Tamil Nadu's legislature. That determination is contained in the legislation itself. So there is a legislative determination. Number two, that determination is endorsed by the president's assent. So the burden will be entirely on the petitioners to demonstrate that even though it has been going on for n number of years, generations, and it begins with Pongal and goes on till May.
Matapam.
Yes. So therefore, the time period is fixed. The breed of cattle which will participate is fixed. It generally coincides with the village festivals which are happening, which may be religious festivals or otherwise, and it coincides along with them. And now even the mosques and the churches are even there organizing. So this is a culture which is beyond caste, creed and religion. And this fact is not disputed. Now, may I place it from para 13, page 13, page 13, para 31.
Of your notes.
Of my note, this is only to take, not in the time. I will take a lordship only through some judgments which are necessary. Since one of the objectives of the State Act is to enable Jallikattu to preserve the culture heritage, a question arises as to whether Jallikattu is actually part of the cultural heritage. Or it is, if it is so, then the people of Tamil Nadu would have fundamental right to conserve the culture and Article 29(1) of the Constitution, and state would be charged with duty to protect it. It is notable that Article 29(1) uses the word conserve, which is wider than the word preserve. Article 29(1) thus confers an active right to preserve, promote and develop the culture. Then we have extracted from Durga Das Basu with respect to Article 29(1), this court has held that its marginal note is misleading. The fundamental right to conserve culture extends to all sections of citizens. The marginal note says minority. So lordships have in the following judgments held that that marginal note is misleading. It is available to all sections. May I turn to page 14, Millards? It has been held by this court that Article 29(1) confers a right to conserve a language, script or culture, and it is absolute. Unlike Article 19(1), Article 29(1) is not subject to any reasonable restrictions. The case of Jagdev Singh read Section 123(3) of the Representation of People Act 1951 in consonance with Article 29(1) and held that this section cannot be read as trespassing upon 29(1) and therefore asking to vote to conserve a language cannot be made a, corrupt practice, not script practice, corrupt practice. In view of the above, the provisions of the PC Act and the Tamil Nadu Act have to be read and construed consistently with the fundamental right of the people of Tamil Nadu to conserve their culture and has not prohibited the conduct of Tamil Nadu, Jallikattu. Looking at the matter from another angle and assuming that the fundamental right to conserve culture is amenable to some regulation, the regulation cannot extend to complete ban of the conduct of Jallikattu. In the context of Article 30 of the Constitution, which confers a fundamental right upon linguistic religious minorities to establish and maintain educational institutions of their choice, this court has held that the fundamental right, now this is a quote from the judgment, it has been held that the article has been couched in absolute terms but has to be read subject to regulatory powers of the state as long as the substance of the guaranteed right is not affected. So therefore, Lord, I'm conceding because of the subsequent development, although that judgment of Jagdev Singh is of 5 honorable judges, which says 29(1) is absolute. But I'm saying, Lord, that much water has flown subsequently. And now we are, Lord, balancing fundamental rights, directive principles, fundamental rights and duties and so on. So, Lord, therefore, regulation is permitted, but you can't ban the culture. The balance has to be there to eliminate cruelties as much as possible. And I've given those judgments notes and paragraphs. Jallikattu is not merely an act of entertainment or amusement, but an event with great historic, cultural and religious value for the people of Tamil Nadu. They, without any distinction to caste or creed, celebrate Jallikattu as a religious event. It also draws huge crowd of foreign tourists who come exclusively to witness the events. Jallikattu traces its origin to Indus Valley civilization, and there are terracotta tablets that depict the organization and celebration of Jallikattu. It's an artistic expression of valor, skill, grit, and determination. It requires intense training both for the bull and the participating humans. It brings out the integral relationship between man and the bull, and not only for the owner who rears, feeds, and trains him for participation, but also for the participant who is required to embrace it, bare-handed for fleeting moment. The embrace is by holding on to the hump. The participant's embrace results in no physical injury to the bull. References about Jallikattu are also available in Silapathikaram and Kali Thogai, both ancient Tamil literature dating back to Sangam era and beyond. The sport Thaluvuthal dates back to the Sangam era, which means embracing the bull and not overpowering the bull. Historically, the sport was also used to choose a suitable groom for young women in the villages, but that's no more there. It used to be at one time.
Swayamvar.
Yes, so sort of. The sport has been an integral part of Tamil culture and heritage for several millennia. Jallikattu is a religious and cultural festival sporting event which bears a religious significance to the people. Each and every event of Jallikattu is conducted during Pongal festival as thanksgiving for a good harvest, and subsequent festivals are conducted near temples. This shows that the event has great cultural and spiritual significance. Jallikattu is given prime prominence even in the school curriculum. The traditional and cultural significance of Jallikattu in its intertwining with the social cultural milieu is taught in the high school curriculum so that the significance is maintained beyond generations. An ancient rock painting is found in Karikayur village near Kothagiri of Nilgiris district, depicting people chasing 3 bulls with sharp horns and huge humps. An ancient rock painting is also found in Kaluthu, Metupatti village near Usilampatti of Madurai district, depicting person trying to control a bull with hump.
Yes.
Also, a painting of a bull with hump is found at so-and-so Theni district. There has been a case study about Jallikattu movement in Tamil Nadu done by Rajiv Gandhi Institute for Contemporary Studies, New Delhi. The study is of March 2020 in para 1.2 and para 2 of the case study. It has been mentioned that Jallikattu is an ancient sport and has been invoked since the last 5,000 years. It refers to the seals of the Indus Valley civilization, Sangam literature, textbooks in castes and tribes of South India, volume 5 by Edgar Thurston, the gazetteer of the Madurai district, etc., to establish that it is an ancient sport of Tamil Nadu, which is part of their culture. So, the gazetteers are referred to and everything, but this is now, the question with regard to 29.1, when we look at 29.1, for a second, if your lordship looks.
Yeah.
Any section of the citizens, you'll also see minority is there in the marginal note, but not in the main part. Any section of citizens residing in territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. So how do we understand this culture is the question. Given the facts which I have mentioned, and that's what I've tried to deal with in page 16 of my notes. The Encyclopedia Britannica explains the advance from instinctive behavior to learned and freely variable behavior, patterns of which may be acquired and transmitted from one individual and generation to another, and finally to a system of things and events, the essence of which is meanings that cannot be comprehended by the senses alone. This system is, of course, culture, and the species is the human species. Culture is a man-made, can you just add environment brought into existence by the ability to symbol. Once established, culture has a life of its own. In Encyclopedia Americana, culture has been explained. It says that predominant use of the idea of culture in contemporary anthropology concerns its signal marking of differences among human population on the basis of language, habits, customs, and modes of thought. It mentions that in the late 18th century German Enlightenment period, the idea of culture became objectified and it came to be recognized as a thing and end in itself. Encyclopedia Britannica also traces the emergence of sports and its conduct in close association with religion and notes the conduct of sports during fairs and seasonal festivals. It also deals separately with crowd behavior and refers to spectator violence in relation to football, soccer, baseball. In para 44, Romila Thapar in her book Indian Culture as Heritage states, every society has its cultures, namely the patterns of how the people of that society live. In varying degrees, this would refer to broad categories that shape life. And again, in the social sciences, culture gradually came to refer to the pattern of functioning in a society with its multiple facets, extending from the foundations to the many manifestations of actions and ideas. The articulation of groups that were not the elite came to be located in the cultural patterns, recognizing at the same time the interface between what had earlier been differentiated as being either art or craft. Yet again, she says civilization is an amalgam of patterns of living with much interaction. She describes heritage as that which is inherited and can refer to objects, ideas, or practices. The intangible heritage is the heritage of ideas and values that may be associated with objects or may be articulated differently, for instance, as performance. In his article, Idea of Culture, Terry Eagleton explains how in 20th century, the idea of culture assumes something of its modern meaning of a distinctive way of life. So long back, it used to be high culture, arts, painting, and so on. Then they had, even UNESCO has recognized that subsequently popular culture. And now they say way of life or pattern of living.
Yeah.
So these articles from Thapar, etc., I have passed on to your lordships. I'm not referring to that because I have elaborated. It is submitted that in case of Nagaraj, this court assumed that Jallikattu is part of the culture of people of Tamil Nadu, but held that the manner in which it is being held is not part of Tamil Nadu culture. The court did not examine the impact of 29(1). Therefore, that judgment is not decisive of the present issue. Evidently, the state legislature is not only legislatively competent, but justified in protecting the fundamental right of people under 29(1).
Yes.
Now, this is important, not para 47. In the Constitutional Court of South Africa, it's an 11 judges judgment, and it was all about the stud which a girl was wanting to wear in the school. And she was a Tamil girl. In the Constitutional Court of South Africa went into the concept of culture and its relation to religion in the context of the entitlement of a female student to wear a nose stud in school. The school had refused exemption from the prescribed uniform. An 11 judges bench observed that culture generally relates to traditions and beliefs developed by a community, and it can have a great deal of overlap with religious practices. With respect to the student, the court held that even on the most restrictive understanding of culture, Sonali is part of the South Indian Tamil and Hindu groups, which are defined by a combination of religion, language, geographical origin, ethnicity, and artistic tradition. Whether those groups operate together or separately matters not. Combined or separate, they are identifiable culture of which Sonali is a part. It went on to hold that cultural convictions and practices may be as strongly held and as important to those who hold them as religious belief. So this is very important, Lord. It's not what we think, Lord. We have to see whether the people of Tamil Nadu, Lord, think that this is part of their culture. Are to those who incline to find meaning in a higher power than in the community of people. It said that cultural identity is one of the most important parts of person's identity precisely because it flows from belonging to a community and not from personal choice or achievement. And belonging involves more than simple association. It includes participation and expression of the community's practices and traditions. The practices and beliefs could differ from person to person within a culture. The particular practice need to be a mandatory tenet and need not be a mandatory tenet and could be a voluntary expression of the Tamil culture. The right to culture would protect the voluntary practices which are part of the culture. So this is an 11 judges South African court dealing with a Tamil girl. Then an article by Professor Chow from Hong Kong published in Human Rights Law Review. I have chosen this not only because it deals with all the UNESCO and everything. Deals with elusive notion of culture in the light of Universal Declaration of Human Rights, the works of UNESCO Committee on Economic, that is CESCR. He classifies culture as high culture, B, popular culture, C, culture as a way of life. This finds support in the writing of O'Keefe also. He explains how the concept of culture has expanded to include popular culture and culture as way of life. According to him, the meaning of way of life is very close to a group's habit of behavior, living style, or the worldview representing the totality of person's encounter with external forces, affecting his life, that of his community. In short, the sum total of material and spiritual activities and products of a given social group, which distinguishes it from other similar groups. It is no more limited to the notion of high arts and popular culture and acknowledges the distinctive features of way of thinking and ways in which people's lives are organized. This is accepted by UNESCO in its report 2001 titled Our Creative Diversity. Therefore, culture is no longer a consumer product, but an expression of the identity of an individual or community, including distinctive features, ways of thinking, and organization of people's lives. In the present case, apart from the material placed through counter affidavit, there is legislative determination. I've already mentioned that. Then when a Jallikattu event is organized during and around Pongal festival, the Tamil people not only participate in the cultural activity, but their participation is actually a cultural expression of their identity and also part of their human dignity. It is much more than an ordinary sport having a religious connect. The State Amendment Act consequently carries out the positive obligation of protecting the fundamental rights of the people of Tamil Nadu, not only in the article.
Jallikattu is held how many times in a year actually?
Sorry, Milord?
How many times in a year is it held?
Only once, Milord, then from 14th of January, the Pongal, Milord, or the Bakar Sankranti as we call, Milord.
Correct.
And up to May.
Up to?
May. And once in a village.
That is immediately after harvest.
Yes. Yeah, only from January to May.
May.
And roughly how many Jallikattus have you?
396 Jallikattus were held, in which 1,17,000 bulls roughly approximately participated.
January 15 to May.
Yes.
Once in the village, in the whole of the year.
Yeah.
Only once in the village.
In every village, it will be only once.
Every village.
Yes. No, not in every village, whichever village. The village has to approach the collector.
That's right.
Then the collector notifies those villages. And only there it can be. Of course, people, somewhere it can be held, people
Without following the
without
law.
that, all those things. But even counting the illegal ones, which were about a dozen or 2 dozen odd,
So roughly 395.
396.
396.
They were the notified.
That is in which year?
2022. Now, if 1,17,000 are participating, and the report which Peter relies upon is of 7 villages based on newspaper articles, assuming everything, what they are.
1,17,000 bulls participated.
Yes. And each bull participated once for that 30 seconds. And all players barehanded. So we are not counting amongst this the rejected bulls. Here are the participating bulls.
What is the discrimination argument of, I think, Shyam, that you are treating some bulls differently from
I'll come to that. I'll just finish this cultural aspect there. So, in Pottaswamy's case, I have given the paragraphs where lordships have said that the state does not have only a negative duty, but a positive duty to effectuate that right. I've given the paragraphs, 113, 125, 326. Then I go on to say, in para 51, that in the modern day world, one finds uneven development of societies. Not only different countries are different stage of development, but even within the country and states, different regions are at different levels of development. Equally, one finds that certain sports have become secularized and are not connected to any religion or culture. But in rural India, there are still certain ancient sports like Jallikattu, bullfighting, cockfighting, etc., which have been conducted since ages and with continuity, and is associated with religious festivals. In view of the aforesaid, it is submitted that it's a cultural event. Now, page 20, I go on to distinguish this with bullfighting. Bullfighting, is often bloody, Sometimes there's a matador, sometimes there are 2 bulls fighting, and there are also bloodless. The point which I am placing reliance, I have given the judgments of Peru and all those, they are annexed. Colombia. So Peru, Colombia, Spain, all of them consider bullfighting to be a part of their cultural heritage. This is very important.
Yeah.
Even France, the Constitutional Court has struck down mullets. And recently somebody tried to put in a bill, but it was withdrawn.
In France, what was struck down by the Constitutional Court?
The local court, the legislatures, they wanted a prohibition. So they struck it down. In Spain also, in Catalonia, legislature passed a prohibition. The Constitutional Court struck it down, saying it's a part of cultural heritage. So this is a incorrect notion, my lord, that a activity which is in nature a sport or an entertainment or amusement cannot be a cultural, cannot have a cultural value. That's very important. Lordship, see, those countries which were colonized by Germany, France, and Spain, all of them, in Africa, etc., Latin America, they have got football. We were colonized by England, so we have cricket.
Football also.
Yes, parts, Goa and Bengal and
Kerala.
Northeast.
They play a lot of football in England also.
No, they didn't bring a football here, no?
No, the English actually brought the football here.
But there's, whatever the culture of cricket is there, football is now coming up. We hope it comes up, with such a huge country and not participating in it. It's an embarrassment. But that apart, point I'm trying to drive through is that a sporting event can also be a cultural event. And especially in the rural areas. Well, what do the farmers do? 70% of the bulls in this country are owned by small and marginal farmers. I don't want to load your lordship with all those statistics, but we have experience about our country in different parts. Most of the bulls and cattle, they are owned by the middle level, small and marginal farmers. Now they can't participate. What do? They go to cinema hall. How do they entertain? These entertainments therefore become a part of the culture of the rural people. The bullock cart race is the easiest for them, as it happens in Maharashtra and Karnataka. When there is no need for telling, etc., the bulls are idle. So, and nobody is asking that the bull should run as fast as the horse. In para 43, in Nagraj, it was said it's two hoof, two bit, cannot run fast as the horse. But horses they are not made to compete with horse. How is this relevant at all? It is bull and who has to cross in 30 seconds.
So possibly the judgment proceeds on the basis that bull is not a naturally running animal.
I don't know from where you get from books. 5,000 years the bulls have been participating in Jallikattu, and we are told that the bulls cannot run. Anybody can open, I don't mind, just see in the net, your lordship will see how fast 80% of the bulls cannot be caught by anybody. They just come out and dash. They are so trained. 80% of the bulls are never caught by anybody. Nobody can hang on it. They fail, they fall around, and they just lie still like this because the bull may not injure them. So bulls have been running in this Jallikattu for 5,000 years, and the judgment will tell us that bull cannot run. There are bulls and bulls. These are special breeds. We are not talking about generally the bulls. There are bulls and bulls. There may be a bull which has been castrated, the bull which may have been dehorned, they become docile. These are all bulls with horns.
Yeah.
And it is for Maharashtra people and Karnataka people to see whether they are the run which is of the bull is sufficient or not. And nobody is asking the bull to run at the pace of horse.
And there are certain other animals also which runs faster than these horses.
There can be a race for slow running also, slow biking.
Cheetah.
Yes.
Cheetahs are there.
Faster. Yet faster, yes.
That doesn't mean that a horse is not capable of running.
Yes.
We are not conducting a race between these two animals.
That's right. I may not be able to run as fast as Mr. Krishnan Venugopal, but I can run a bit.
50 meters.
Yes, 50 meters dash.
My friend has run far ahead.
Yeah.
So therefore, my lords, this I don't know if your lordship wants, I can read these judgments. I have given the paragraphs, I have annexed the judgments.
It may not be because you've given a detailed note. No?
I have given a detailed notes. I have given the paragraphs also.
We'll have to go through that.
Yes, but the other point which I wanted to, the 2 points which I want to make on this foreign judgments. One, that bullfighting is recognized as culture. Second, my lords, that these judgments have tried to cull out duty from the aspect of environment, sentient being, nature.
Can be regulated.
Yes.
Can be regulated.
Can be regulated, certainly.
Should be regulated.
Should be. It has to be balanced with compassion, etc. to the whatever extent possible. As I said, whatever is inherent, which is unavoidable. For example, when from the body vessel, the bull is to come out, sometimes you have to just prod it, nudge it to move to it. Now, You may call it poking and this and that, but whatever you may call it, I say, my lord, that this is not a cruelty, my lord, at all. If with a stick you just push it, no bull, my lord, ultimately they are animals, my lord. Sometimes they may sit down, so they have to be made to stand up and move out of the arena. So all that limited minor things can happen, but yes, no
Necessary pain theory, necessary pain.
necessary pain.
And that is recognized in Nagaraja also.
Yes.
Para 70 last.
Yes.
Para 70 the last sentence. It
That's
says,
right.
further animals like
So
cows,
duty
bulls,
has been. I'm sorry.
it says like this, further animals like cows, bulls, etc. are freely used for farming, transporting loads, etc. That too for the benefit of human beings and thereby subjecting them to some pain and suffering.
That's it.
So that is taken.
That's the necessary pain.
That is taken note of.
So therefore, not the second aspect is that these duties have been culled out and sought to be balanced. In Ecuador case, my lord, as I said, my lord, they have tried to weave out from the nature, etc., a subservient right. So you may call it a subservient right, you may call it a duty of compassion, and whether draw it out from sentient being, draw it out from nature, environment, or Article 51A, ultimately they cannot override the fundamental rights. They have to be suitably coordinated and balanced, my lord, keeping that the fundamental right,
Yet
they are subservient. Ecuador says that they are subservient to the human rights.
Okay.
So I'm not reading your law. Your lordship may kindly go through this. My lord. There you go. My lords wanted the Ecuador judgment, my lord, which we were able to take out subsequently.
we've got it, I thought.
Your lordship got it?
On that day it was made available.
Not we given it.
Achha, it's all right.
You've given it.
I will just give a piece of paper, the paragraphs. My lord.
No.
You can make it available. You give a copy.
You can
to
pass
all.
on, Mr.
You
Dwivedi.
can pass it on.
All right.
Pass it on, please.
You have it, huh?
Yes.
Now, my lords, with that, I come to this question of Article 14, my lord, manifest arbitrariness rules. So my submission is not that is Jallikattu is part of culture, and state is obliged in law to act positively to protect it. Then balance it not with the duty cast. Now, page 22, my lord, is where I deal with this. One aspect may be noted, my lord, that the question which has been framed doesn't, my lord, contain any of this manifest arbitrariness independently. The question framed is, does the Tamil Nadu Amendment Act go contrary to Article 51A, G and H? And could it be said, therefore, to be unreasonable and violative of 14 and 21? That's the question framed, but I don't mind my lord answering what they have argued. Now, my lords, one question which I wish to convey, my lord, and request your lordships to decide is, how do we, my lord, what are the parameters of manifest arbitrariness? Is it a subjective phenomenon, my lord, that in a particular case, the learned judges think, my lord, based on their, my lord, feeling of how it should be, and then, my lord, we decide that it is contrary to that conception, and hence, my lord, manifestly arbitrary? Or is it, my lord, something which has to be grossly or shocking, my lord, to the conscience? To that extent, my lord, you have to go to hold manifest arbitration. What is otherwise, my lord, the principle was laid down by Justice Nariman, my lord, departing from McDowell, my lord. In McDowell, he had appeared as a counsel, and Justice Jeevan Reddy, my lord, did not accept it, that legislations cannot be struck down. But then, as a judge, my lord, he ruled that that is available. But that's aside, my lord. He was entitled to. He says that now with Maneka Gandhi's free, fair and reasonable requirement in Article 14 and 21, we have gone back to the due process scenario in America. Question raised before the 9 judges in Aadhaar by me was, is that so? Are we bringing back due process which was expressly rejected by Dr. Ambedkar in the Constituent Assembly?
Possibly Maneka Gandhi does introduce
So therefore I'm asking, Lord, how do we go about it? But in 9 judges, Justice Chandrachud, Lord, speaking for the majority, says that no, we are not bringing in due process. And if you Lordship may just note paragraph 290, the judgment is 2017, volume 10 SCC, page 1. Para 290 to 296. Maneka Gandhi has been considered. Dr. Ambedkar's speech has been considered.
But Mr. Dwivedi, 14 kind of confers a right on a citizen
Yes.
to question legality of a statute on the ground of arbitrariness. Why should manifest arbitrariness shall not be an assault weapon
I'm not saying
from the
that.
citizen's point of view?
I'm asking posing a different question. I'm posing a question: how is this manifest arbitrariness to be determined? Of course, case to case.
One answer is that we know it when we see it.
But the point is, my lord, your lordships have to declare the law for the nation, my lords. So when your lordship will be declaring it manifestly arbitrary, my lord, we must know not only the lawyers but the people, my lord, as to how your lordship's mind functioned, my lord, when the lordships held that it is so. Of course, my lord, we know, my lord, that by now, my lords, at the fag end of our careers, that is ultimately what your lordships decide. But then, Lord, that's the majesty of this process, that when your lordships decide, your lordship tells us, Lord,
not any of our court. This is by an American Supreme Court judge.
Yes. Your lordship is right.
Justice Porter, possibly.
Yes.
Commenting on obscenity, what it is.
Yes. That's right. There is an element. Even Justice Patanjali Shastri, my lord, has said, my lord, that some element of values of the judges is bound to enter into that. So there's no objection to that.
Some element of the legal culture.
Correct.
It's not only the judges are not.
But even judges, it happens. We have been watching. There were days where, when rent control matters used to come before Justice Desai, I believe just had to say, that's a tenant's matter. Notice issued stay. So judges' inclination does count.
But the social culture.
But I will not call it manifestly.
Social culture was also different at that point of time.
Yes. That's right. So with changes in society, everything changes. I'm on a different question. Some parameters, please lay down. That's what I'm asking, because high courts are also there, my lords. High courts can also apply Article 14, my lord, to judge the validity of acts and regulations and so on. So manifest arbitrariness is not sufficient in my humble submission, my lord. Something more needs to emanate so that one can judge and apply those tools, the parameters. And I submit for the lordship's consideration that it should be so shocking, and because after all you are dealing with legislation. And what happens, my lord, in legislation, that there is a presumption of validity. Then there are constitution benches saying that the legislators understand the needs of the people. Then number 3, your lordships have said that wide latitude will be given in matters of policy, legislative policy. So with all these words, like a batsman in the cricket match, when we stand up, we wear with all these pads and gloves and thigh guards and everything, presumption of validity. So, which your lordships have been kind enough to extend to the legislation. So given all these things, and then also the principle and evidence act, that official acts have been done regularly. Judicial restraint. So all these principles will have to enter into while judging manifest arbitrariness. And that's what my lord has been laid down. If your lordship just note down paragraphs 290 to 296. I will just read, my lord, from 292. In dealing with a substantive challenge to law on the ground that it violates a fundamental right, there are settled principles of constitutional interpretation which hold the field. The first is the presumption of constitutionality. I'm sorry, my justice has got it. Page 495, bottom 292.
Yes.
In dealing with a substantive challenge to a law on the ground that it violates a fundamental right, there are settled principles of constitutional interpretation which hold the field. The first is the presumption of constitutionality, which is based on the foundational principle that the legislature, which is entrusted with the duty of lawmaking, best understands the needs of society and would not readily be assumed to have transgressed a constitutional limitation. The burden lies on the individual who asserts a constitutional transgression to establish it. Secondly, the courts tread warily in matters of social and economic policy where they singularly lack expertise to make evaluations. Policy making is entrusted to the state. The doctrine of separation of powers requires the court to allow deference to the legislature whose duty it is to frame and enact law and to executive whose duty it is to enforce law. The court would not, in the exercise of judicial review, substitute its opinion for the wisdom of the law enacting and law enforcing bodies. In the context of Article 19, the test of reasonableness was explained in the erudite words of Justice Patanjali Shastri in V.G. Rao's case. It is most important in this context to bear in mind that the test of reasonableness, wherever required, should be applied to each individual statute impugned, and no abstract standard or general pattern of reasonableness can be laid down as applicable to all cases. The nature of the right to have been infringed, the underlying purpose of the restrictions imposed, the extent and urgency of the evil sought to be remedied, disproportion of the imposition, the prevailing conditions at the time should all enter into the judicial verdict. In evaluating such elusive factors and forming their own conception of what is reasonable in all the circumstances of a given case, it is inevitable that social philosophy and the scale of values of the judges participating in the decision should play an important part. And the limit of their interference with legislative judgment in such cases can only be dictated by their sense of responsibility and self-restraint. And the sobering reflection that the Constitution is meant not only for people of their way of thinking, but for all. And the majority of elected representatives of the people have been authorizing the imposition of restrictions imposed, considered them to be reasonable. The court, in the exercise of its power of judicial review, is unquestionably vested with constitutional power to adjudicate upon the validity of law. When the validity of law is questioned on the ground that it violates Article 21, the scope of challenge is not confined only to the procedure of deprivation of life, and liberty is fair and just reasonable. I just come to 296 only.
We'll read it. We'll go through the paragraphs you mentioned it.
All right.
Otherwise, we have to save time. We have to conclude today.
In 296, they have said, Lord, that due process doesn't apply. So, Lord, my argument partly was that it does. This theory, Lord, is go back to McDowell. But they said, no, after Maneka Gandhi, etc., now this can be applied to substantive law also, but with all this padding rules. And then now, the other thing.
We have to do the Maharashtra round also, Karnataka.
So, the learned solicitor is dealing with it. He said he'll take half an hour. Mr. Rastogi will take half an hour. So, we'll finish by not beyond 3 minutes.
That's it.
No, I'm all of that. I'm trying to finish before lunch.
Yeah.
Now, my lords, at page 23, I have set out, my lord, judgments which show that merely on the basis of Article 51A, you cannot strike down a law. Paragraph 61.
Cannot strike down.
Yes.
Fundamental duty.
And if Article 21 and 14, both of which use the word person, so there is no fundamental right, my lord, and Justice Radhakrishnan was wrong on that. Hold it. A fundamental right. That was one important underpinning of that judgment. Apart from that repugnance, it was 21. Repugnance has been cured, 21 is erroneous. And he doesn't discuss this aspect at all, not in detail. So again, Lord, I am not reading those judgments. You also will see, Lord. It is one thing to use 51A for interpreting or for balancing at the utmost. But by itself, it cannot be used. For example, directive principles cannot be used by itself. Otherwise, everybody would be asking for a mandamus to impose prohibition or something because they don't want it. And most states, depending on that, revenue will be extinct.
That's right.
So, Lord, skipping that, now I come straight away, Lord, the question of finding of fact, Lord, argument. That is sought to be overruled. My first response to that is
Para 53 to 55.
yes. That the finding of fact was actually summed up in 53-55, that the manner in which, that is one.
And you have to correlate it to para 31.
Yes. 31.
Of the
It was
judgment.
pointed out, Mr. Sibal. So
Yes.
yes. The second thing is not that a finding of fact in every case depends upon the facts which are produced in that case. They are never in absoluteness. In fact, Lord, it has been said that most of the time, Your Lordship, when it records the finding of fact, Your Lordship says that it appears on a perusal of the affidavits, etc., that this is so. And there was a report of Animal Welfare Board, Lord, which is a statutory body saying something. Today, they are have a different version to state. PETA, of course, Lord,
The basis is completely changed.
change. The third aspect is, Lord, that the finding of fact has had two parts. The first part was that there is cruelty being practiced. And in 2 or 3 paragraphs, in great details, Lord, from the affidavit of the board, it was recorded. The other part of the finding of fact was that because of his anatomical behavior, nature, and behavioral nature, and they being fearful inherently. So my answer is not that the second part is being taken care of by 11.1 read with the rules. And the fact that PETA has only spoken about 7 events out of 396 is indicative of the fact that
How
there is
will 11.1 deal with the anatomical part?
no second part,
Second
cruelty part.
that is the first part. You said first.
Oh, I'm sorry, I stand corrected. The first part of cruelty has been dealt with by 11.1 is preserved, except to the extent Jallikattu it is inherent. The second part about inherent, that is taken care of by the exemption.
Yeah.
So therefore, my lord, there is a completely different scenario today before your lordships. And in fact, Lord, the judgment of Tamil Nadu versus Kerala in para 155, that is 2014-12 SCC 696.
Paragraph
155, 2014-12 SCC 696, State of Tamil Nadu versus State of Kerala, that is that dam matter, height of dam, para 155. That supports our case because it's expressly said that if the circumstances have changed, then a review can be sought. So I have dealt with this lot in page 29 to 31 of my note. And then comes not the aspect of this non-retrogression.
Mr. Dwivedi,
Yes.
you see the circumstances change. If you just go back to para 18 of Nagraj,
Yes.
because you see what they said is they try to run away from the arena, the bulls, but they can't do it because the arena is completely closed. But we are getting a situation here from the chart that has been, the picture that has been given,
Yes.
is that they go on to the, after the holding arena, then the running arena, and there is open space.
Collection point.
So there is no enclosed, totally enclosed arena,
Yes.
where this particular paragraph 18, perhaps there is a bit of a misunderstanding then.
That's right. I'm grateful for pointing this out. Now, my lord, there is a clear passage given.
No, that's what I'm trying to say. There's a bit of a distinction on the factual aspects that were noticed in Nagraja as compared to what is being presented now,
Presently, my lord.
or the legislature might have had in their mind.
That's right. That's right. Now, my lord, on view of the rules, the area prescribed, everything has been done so that there is a clear passage. In fact, my lord, sorry,
Yes.
in fact, my lords, some of the photographs which your lordships must have seen, my lords, your lordship will find that when the bull is going back to the village after having taken part, then on the way, my lord, the owner is carrying, the crowd collects and the crowd, my lord, harasses.
That is the collection here.
So one that is, no, that's on while going back home outside the collection area.
Outside.
If, please see the photographs again. You'll also find none of those individuals are dressed up as a participant. So the spectators, not they collect around and they not. So that is crowd misbehavior. One, it happens in a number of sports, not particularly football, etc. We have seen not the crowd misbehavior. But I have myself not told the authorities that your duty does not end at the collection point. You must ensure that when the bull is being taken back, then at least up to the market area, etc., until the bull leaves that, this kind of a crowd collection doesn't happen. Because some of the injuries which are pointed out happen there. In the bull area, a stray case could be if the bull instead of going after going to the collection point wants to come back in its rage. They collide or something.
Could it be because you are prohibited from administering alcohol beverage to the bulls?
Yes.
But it is not applicable to the spectators.
Yes, not. That's right. Of course, that's possible.
The humans do it outside the arena.
Yeah, that's right.
Everywhere the crowd misbehavior, one of the reasons for it is that excitement.
But this World Cup, we are not seeing that kind of a thing.
Yes.
They have prohibited beer, etc.
But some time back, it happened in the cricket match between Afghanistan and Pakistan. But that be that as it may. So I'm grateful for this paragraph. So, Lord, one, the basis of the previous judgment has been cured by taking care of, by taking the route of 254 and having the assent. Second, Lord, we have pointed out the errors in holding that 21 gives a fundamental right. And third, my lords, there are other errors in this, which I have already pointed out and Mr. Sibal pointed out. Now coming to non-retrogression, my lords, my learned friend should have mentioned it to your lordships in Navtej Johor's case, that is 2018-10 SCC 1. This is on non-retrogression now, my lords. A paragraph was read, my lord, from Justice Deepak Mishra's judgment. That's not the majority judgment. Justice Chandrachud and Justice Nariman don't refer to that. The other error committed by them was that there is some other reference of non-retrogression, Lord, in Siddique's case, M. Siddique versus Suresh Das, which they did not refer. But in fairness, Lord, I have pointed out in para 88, 2020, volume 1, FCC, page 1, para 102, where, Lord, the legislative non-retrogression was talked about. Not that in judicial review, based on non-retrogression, Lord, a provision can be struck down. You all shall recollect in Places of Worship Act, Lord, it has been said, Lord, that 15th August is the deadline cut-off date. The character as on that date will be maintained. It's challenged, but that's a different thing. So in this judgment, Lord, while dealing with that Ayodhya matter, this court talked about legislative non-retrogression. Because the law is saying, not the court is saying. Apart from these two judgments, there are no judgments where this court has applied the doctrine of non-retrogression. It is a doctrine, Lord, which is not yet firmly rooted in US. The US court itself it had applied this doctrine in the context of race cases. For example, that you have abolished segregation. Now you can't go back. But that is not directly connected to the equality clause. So this is a constitutional provision which they style it as non-retrogression to prevent the legislature from going back after conceding a right, valuable right. So they were mostly race cases or voting right cases, that if you have granted not a voting right to citizens up to 18 or 21, now if you want to go back. So, but it has received a lot of criticism. I have annexed one such in para 86. The Lordship may note, Lord, in para 86, I have annexed. So it is much better, my lord, to deal with ultra-virus based on Article 14, 19 and 21, rather than, my lord, strike down a principle, the statutory enactment on the basis of non-retrogression principle, which is not yet firmly, my lord, rooted in US even itself.
Yes.
It happens, my lord, it's very enchanting, my lords, to borrow, my lords, narrow tailoring, etc. Things get settled down in due course of time, you know. But to just mechanically adopt the principle and apply it, Lord, will cause serious. So every time our legislatures are having plenary powers, they can legislate prospectively and retrospectively both, subject to the constitutional fundamental rights. So therefore, to say that there can't be retrogression, and lastly, in our case, no retrogression is involved. Until 2014, Jallikattu was being conducted. It is only when the central government passed a notification under Section 22 of the PC Act, saying that bull is not a performing animal, Then, my lord, this controversy arose and it has been rectified promptly, my lord. So consequently, there is no rectification involved, my lord. And at the end of the day, my lord, the lordships, my Lord Justice Joseph, my lord, wanted me to respond to that classification.
That's what are the contentions raised?
But classification, sub-classification, I have dealt with in para 32, my lord. Para 32, if the lordship will see, my lord, 37. I have extracted, my lord, from that also.
Yeah.
The sub-classification of bulls has to be tested on the same twin test, my lord. Is the classification having a rational objective? So we are preventing other bulls which do not have the hump, etc. So these are special breeds which alone can have been historically used for this. So it is limited to those bulls.
Only with the hump.
Yes. And the hump bloods.
Only in the alignment of the legs.
Alignment, yes.
In alignment of.
Those are right. Right.
Not otherwise.
Yes.
It can bear the
Yes.
embrace.
Embrace.
That's right. So therefore, that is not. And lastly, I say, Lord, let's not forget also, Lords, the bulls are facing a much more cruel world today. Why I say that? Tractors have come in, harvesting machines have come in, transport
Not
vehicles are there.
Not needed anymore.
So, Lord, what do these bulls do? Where do they go? PETA, Lord, unfortunately, there's no facts, Lord, but I investigated and found, Lord, that bulk of the meat goes to US, Lord, to where PETA belongs. And most of the mutton, Lord, which is the meat which is going, beef which is going exported, Lord, is from UP, Delhi, and Lord, this area, not from the south. So what happens now, Lord? Are we pushing these bulls, Lord, to save them from this small suffering and pain to the slaughterhouse, Lord? This is the question which I am posing, Lord. Let's not forget this, Lord. And if the legislature wants to avoid that, Lord, can it be said to be manifestly arbitrary, etc.? So the only destiny of these bulls at young age would be the slaughterhouse. It's a matter of common knowledge, Lord, that this mechanization is happening.
They are used to fight up to what age actually? From between 2 to 4, 7. Somebody said 2
to 6 years.
2 to 6 years. And they survive till 20 years.
And round the year, they are maintained by the farmer for this occasion. See the larger picture. Forgetting whatever PETA may be having, that by your side I said, there isn't any material on record to say that. But this is definite. Your lordships can take judicial notice that because of mechanizations, harvesters and transport vehicles, the use of these animals as draft animals and pack animals has drastically reduced. So what is to be done? For what will the farmer maintain them? Either just leave them, abandon them, and then the farming will be disturbed. Where will the farmers go? Into anybody's farm. It will be like a bull in China shop. So therefore, this cannot be overlooked at all, which is completely lost sight of. We are overemphasizing, my lord,
Animal rights.
the pain, etc. But surely, my lord, frying pan and fire, my lord, is much more cruel. Let them live their life at least, my lord. We can tolerate castration, etc., my lord, which destroys their life. Branding. Why is branding done? Because I must know it is my bull. For this purpose, identification purpose, my lord, branding is necessary. How cruel that branding is, how painful it is. So, lordships will look into all this aspect, my lord. This is much less, and it's.
You place the other side of the picture. Place the other side of the picture.
Competing petition for farmers matters as well as bull owners. Can you hear us talk?
You have to conclude by 3. All that we are saying. Whatever the reply will be concluded today. This case will be reserved today. Isn't it?
After solicitor argues, we will have 5-10 minutes for each.
No. See, whatever is said is said. That is taken.
We will not repeat.
You don't have to repeat again and again. There's no number.
Give us some time tomorrow. Short time.
Today.
Good.
We are just completed.